Okay, so I recommend we start already. I'm gonna share my screen. Please let me know if you can see the screen.
Yes.
Okay, perfect. So, hello everyone. My name is Hafiz. I'm legal advisor and founder of Boundless Consultancy. Today, we're going to talk about employment and fiscal law of Switzerland. Of course, not all the employment law and not all the fiscal law. The most important points for you as either if you're shifting in your careers or you would like to understand your legal rights for employments, basically after you start your first job, what is the working hours, how is the work contract, what is the most important things you have to look at once you sign a work contract. We will talk about different permits and the difference between the permits as well at the beginning, and then we will um, discuss mostly the taxes, social security, and all of that, which are very, very important once you are basically either you start your own business or you are employed in Switzerland. So, a small publicity for my company. We founded in 2021 during the COVID. We are also immigrants, and we wanted to help other immigrants to understand their rights in Switzerland. So, since the war began in Ukraine, we offer our services for free for Ukrainians, and we still offer the first consultation free of charge for everyone to check if there is anything we can do for them, basically, to avoid paying lawyers for nothing, basically. So today, overview of topics. We're gonna talk about this 11 subjects, the work permits, the difference between EU, EFTA, and third countries. Third countries, which is, we call them third countries, they are not part of the EU or the EFTA, which is Liechtenstein, Iceland, and Norway. We will talk about working hours and overtime, types of work contracts, minimum wages, and internship, apprenticeship, and volunteering, employment rights and protection, social security, and financial assistance for employers. We will come to this later, and contract termination and dispute resolution. So let's start. And please, if you would like to ask any questions, just raise your hand or you just speak. Don't wait at all, because I would like this session to be interactive as much as you can. Please use this time with me. Ask any questions. If I have the answer, I will definitely answer you directly. If I don't, then I will come back to you later on with the answer. So let's start with the easy one, which is the EU nationals. EU nationals, they have the right to work in Switzerland because they enjoy the free movement agreement between Switzerland, EFTA countries, and the EU. This free movement agreement, it allows the European to come and work in Switzerland freely. They need just to show that they have a work contract if they are employee, and the work contract at least need to be 50%, which means to cover at least 2,000 to 2,500. Then they receive a B permit, valid for 5 years. And they need also an address, of course, in Switzerland. They will be subject to health insurance taxes. Once you establish your residency, you will be subject to all taxes and social security, basically. After 5 years of B permits, some nationalities, not all EU nationalities, that Switzerland concluded an establishment agreement, like Italy, like France, like Portugal, they receive automatically a C permit, which is a long-term permit in Switzerland before nationality. That's the more secured one before you get your Swiss nationality. If you are looking to establish as a freelancer or activité indépendant, then basically you have to show that you have the financial resources to cover yourself until this activity start generating revenue. So you need to submit to the authority a business plan with projections, and these projections need to show that you have the financial means to cover yourself without asking for social welfare. Now, what does mean exactly? It depends on the canton you are living in. Some cantons, they will look for the minimum, what we call it minimum vital. This is like in Geneva, for example, the minimum vital is around 4,500 for one person. So basically, if you are in this, you need to show at least 6 to 10 months of investment that you have this money until you start generating money for the authority to accept to give you a B permit based on freelancing activity. As I said, it depends on the canton. Zurich, I believe it's more expensive, so Valais is less. It depends on the canton, it depends on the activity, and we will see later that you will need to have three different clients if you are a freelancer. Your one client, you are not considered as a freelancer. You will be considered as employee for an employer that is not registered in Switzerland. Um, what else for the European normally? Also for freelancing activity, the permit is valid for 5 years. If you wish to switch from freelancing activity to employment activity, you don't need to do anything. Your B permit is valid for both, but if you wish to change from employment activity to freelance activity, then you need to ask for another permit. As in employment, you can start immediately. You don't have to wait until you receive the B permit because some cantons can take up to 2, 3 months to give you the physical card. At this time, as a European, you can start from the first day you sign the contract. You don't have to wait for anything, which is not the case for non-European. Here we have the L permit. This is the short-term permit. If your contract is less than 2 years, basically you will receive an L permit. The difference between L permit and B permit is for stability, basically. If you're looking for a long-term staying in Switzerland, so L permit are not counted, the years you spend under L permit are not counted towards nationality, nor towards the C permit. And your family unification rights is limited, basically. The authority will allow, but is you have to do the request unlike the B permit when you have the right as a European to bring your family. So as well, if your family members would like to work in Switzerland, they need to ask for authorization. So it's not automatically because family members of a B permit holder will receive a B permit holder with the right to work. Family members of L permit, they will receive L permit without the right to work. So they need to ask for the right to work, basically. This is only for contract that is less than 2 years. And basically, after 2 years, it should be either you leave the country for a couple of months and you come back and you ask for another L permit, but you cannot ask for another L permit after 2 years. It's blocked 2 years. G permit, this is for the cross-border workers, people who lives in other country and work in Switzerland, always for the EU national, what we call it frontalier permit. This one is linked to your employer, basically. It's also valid as long as the contractual relationship is valid. In this permit, there will be written who you work for, basically. So if you work for Boundless, there will be written Boundless Consultancy. And once you finish working with Boundless, I have the obligation to tell the authority that you are no longer working for this company. So if you wish to work with another company, then you have to issue another G permit. CI permit, this is for the international organization. I don't know if there is anyone here from the international organization or were working in the international organization. Okay, so I will go fast. CI permit, basically, people who works in the international organization normally receive what we call it carte de légitimation. This carte de légitimation is basically in parallel system to the immigration system in Switzerland, is issued by the Federal Department of Foreign Affairs, not with the cantonal immigration authority. And they cannot work under the CDL, their family member, they cannot work under the CDL. They will receive what we call it CI permit to be able to register for Social Security and pay taxes and everything. C permit we talked about. C permit just to it's unconditional and unlimited, so you don't need to have a reason. Everyone in Switzerland except Swiss people needs a reason to be in Switzerland. Either you're here for study, or you're here for as a family member, or you're here for work. So once you get the C permit, you don't need to justify the reason you are in Switzerland. You are in Switzerland because you are You are a permanent resident, basically. So the authority, once the renewal come, they will not ask you to provide any documents, basically, just to show them that you are here in Switzerland. And of course, if you commit crime or something like that, they will revoke it. But if you're good and everything, and if you ask for social welfare, then they downgrade it to B permit. Other than that, you will keep it forever, and you are allowed to leave the country under C permit or a B permit for 6 months per year. If you pass the 6 months per year, then your permit will be cancelled, basically. Now we're going to talk about the third country nationals, the people who are from not from the EU or IFTA countries. The conditions are way more difficult for them to be hired in Switzerland. In general, just to let you know how strict Switzerland is, basically 4,500 B permit is given every year in whole Switzerland. So only 4,500 people allowed to come and work in Switzerland under a B permit. It's this 4,500, 2,500 is distributed between the cantons. Canton Zurich has around 200 something, Geneva around 100, Vaud around 70, and then there's 2,500 with the federation in case the cantons use their own quota, then they can ask from the federation. But in any case, but just to show you how strict they are about who will come and enter Switzerland and work in Switzerland. As I said, the application, sorry, needs to be submitted by the employer. Employer is the one who will do the whole process for engaging someone from outside the EU. They need to go through first the hiring, the priority list, which normally by law, employers need to prioritize Swiss citizen, C permit holder, B permit holder in Switzerland, and countries with whom Switzerland signed an agreement for free movement, which is EU and EFTA. So the employer, before he or she engaged someone from outside the EU and EFTA countries, they need to show that they did a lot of research to find a suitable candidate in Switzerland and in the EU to be able to hire someone from outside. So they need to publish the post they want to in all the work media like Job Room, LinkedIn, everything. They might use also agencies to try to find them a suitable candidate in the EU and Switzerland. If they use all of that things and they still couldn't find a suitable candidate, then they can go ahead and hire someone. Of course, this person they would like to hire is not going to be a first employment. He needs to be what we call it cadre, that's higher than the first time. And he needs to be, or she needs to be very qualified, basically. So either they have a long experience or they have a master degree or PhD or something like that. Now, that's what we call it B permit with quota, which means that basically durable, we call it even. That means you took a place in the quota, which is the 4,500. That makes your B permit durable. Once you get this durable B permit, then you can change employment in case you have to, basically. We will come back. I would see if we mentioned here the non-durable one. The criteria, the most important one is the economic interest. What is the economic interest for Switzerland to have this person? So you see the employer has to go through a lot of things to prove many things. Basically, they need to have a profile with the immigration, how this person will help them to increase their revenue or to get to the project they put in place, many things. It's valid for 1 year. Every year it should be renewed. So the next year they will come back and say like, okay, send us your payment slip and your work contract, basically to check if you're still working or not. First 2 years there will be renewal yearly. After that it will be 2 years, 2 years. Now after 5 years, couple of nationalities can apply for a C permit, like American, Canadian, Australian, Japanese. There are many other nationalities because we have this agreement with, so they can apply for a C permit after 5 years. or 10 years, which is the normally it's 10 years for the other people. And there is accelerated 5 years C permit application if you are exceptionally integrated in Switzerland. Exceptionally integrated means that you speak the language very good, you participate in a lot of social activities, like you volunteer a lot, you are member of couple of association, you show attachment to Switzerland more than an average person who is here to work and leave, basically. Once they see that, they compensate you with the giving you a C permit after 5 years, not 10 years. So that's very important. Also to keep in mind the integration process. The integration is very, very, very important in the C permit application or B permit in case you lose your right to work. Short permit, L permit, exactly the same. Still, the employer needs to do that everything, economic interest, the same as a B permit, but the contract is maximum 24 months. There is another quota, I didn't mention that. There is another quota for L permit holders. So I think the quota is around 7,000 something allowed to come every year on L permit, basically. There is a specific quota for British national. So after Brexit, the Switzerland and the UK signed an agreement to allow only UK nationals. They have their own quota, which is around 2,500 B permit and around 4,000 L permit, basically. So that make it easier. Also, third country nationals are allowed to get the G permit cross-border, but of course the conditions are way, way higher than the European. They need to be living in the border for at least 12 months with the long-term residency. So that means that they need to have, for example, I know in France, they have the carte de séjour de 10 ans. It's like 10 years carte. And then if they don't have this carte, then they're not allowed to come and work in Switzerland. But also the employer needs to go to the hiring process and see if there is anyone in Switzerland or the EU have the same qualification. It's valid for 1 year and it is renewal every year, basically. In practice, I rarely seen this permit in all my life. I never seen a cross-border from different nationality obtain this permit. Never. Here there is asylum seeker. They receive N permit. N permit, which is basically not a permit, I will call it, but it's like a small paper to show that they are waiting for their decision in Switzerland. And after 3 months, they can ask for an authorization to work, which is very difficult to obtain as well. But yes, they have the right to work after 3 months. F permit, temporary admission. This is basically if you have a war in your home country and you cannot go back. Basically, in this way, they grant you temporary admission until the situation in the home country is good, so they can send you back, basically. During this time, you're allowed to work. Employer only need to notify the authority that you are working for this employer. They need to submit the work contract and a copy of your F permit, livre F they call it, and it's renewal every year until, as I said, the situation has become better in the home country. Now there is a lot of synergies between F permit and S permit. Now they are almost S permit is now better. Before it was kind of F permit better in one things, F permit is good for another things. S permit for Ukrainian who flew after the war, basically. They have the right for family reunification better than the F permit. They are freely allowed to move around Europe and go to their home country, which is not the case for the F permit holder. Before, employer needed to get authorization for S permit holder to work. Now it's not the case anymore. At the end of October, the Conseil Fédéral changed the rules to be exactly like the F permit. So now the employer needs to notify the authority that this person is working. It's very fast, it's easy. The person can work without waiting for any authorization, which was difficult before. In Geneva, I asked for a work permit for an S permit holder that took up to 3 months. And basically, employers normally they don't like to wait 3 months to get an authorization, especially when the government is pushing for employers to hire S permit holders. So this is not the case anymore. It's becoming easier and better and faster. Any questions about the permits? Okay, no questions. We will move to working hours, which is, as I said, if you wish, this is the working hours in Switzerland. Daytime work start from 6 to 8. Evening work is from 8 to 11. Normally, you need an authorization to work at night. Employer needs also an authorization to hire people at night. Only couple of activities that is allowed to work at night, like in the station, basically in the train station, in the hotels, and a restaurant and this kind of activities. But otherwise, like you're not allowed to open as a shop, closing shop or magazine, and just to open until late, which it's not allowed basically. Maximum weekly hours for office workers is 45. There is a law, which is Loi sur le travail, that only, of course, other activities might do 50 hours per week, but normally for office worker it's 45 hours per week. Now, if we pass this 45 hours per week, that will be what we call it extra hours. We will see it in the next slide. Um, for maximum weekly hours for non-corporate can be up to 50 hours, and because employer must consider employees' families' responsibility and when assigning works hour. I don't know if you're following the news now, but you can see that there is a strike, people who works in the constructions. They were I don't know, they still striking, but they were yesterday and the day before. I think the day before was in Lausanne. So we will see why they were striking, because we will see that there is Convention Collective de Travail, which regulate the whole branch of this activity. And now there is a discussion between the employers and this syndicate and the employees to modify it. So employers would like to have more rights, employees would like to have more rights, and there's a conflict now. I don't know if they will solve it soon or not, but people still striking basically. Employees are entitled to time off if their children are sick upon presentation, of course, of medical certificate. And of course, if they're sick, here that it will be based on how long you've been in the company. So the first year of service, you're allowed to take sick leave up to 3 weeks. The second to fifth year of service up to 1 month. The second 6 to 10 years of service up to 2 months. After 10 years, up to 3 months. So normally employers, what they do is basically to have what we call it insurance to cover this time. Yes.
I have a question with regards to the time off when the kids are sick. How does it work? So, what should I present to employer? Is it like a sick leave for a kid, and for how long am I entitled to have a sick leave then?
You or the children?
My kids,
Your
if
kids?
my kids are sick.
Yes.
Time off for sick children, you
Yes.
mentioned.
Yes. Well, basically, if your children are sick, you have to present a medical certificate. I believe it's 3 days, and then you have to find a solution for them. But normally it's 3 days that you're allowed to be paid for this sick leave. That's what we here. Everything we're talking about is paid, basically. It's not unpaid. So I believe it's 3 days
Per
paid.
year,
Yes. No, not per year, per time, per once.
per sickness,
Per sickness,
per sick
exactly.
leave.
Yes. And then you have to
I-
find a solution, basically.
Is it possible that you can give a reference to the clause or to
Definitely,
the law
definitely.
with
Anyway,
regards
that
to that?
this presentation will be sent to you. I will add the reference here to the federal website, and you can see basically the information.
Thank you very much.
You're welcome. Exemption to starting working hour for those working industries who are fluctuate seasonally are due to weather conditions possible to extend the workday by up to 4 hours. This is like very specific. So there is a way to extend it for the employers and for the employees to basically they cannot, if this is the case, they cannot basically they cannot do anything basically. So that's overtime. This is very important for you to know. As we spoke before, we saw that office time is 45 hours. If you pass this 45 hours, that is overtime. Basically, overtime is paid with an additional 25%. And needs to be cannot be forever. They have only not go over 2 hours per day per worker and only take place in a day or evening, not at night. This is except, of course, if there's emergency in the employers and needs you to come at night to solve a problem. But this is very important to know that the payment is not the same. So if you do work extra overtime, sorry, you have to be paid differently, and you cannot continue working more than two hours, basically. So this is an example here. Normal hourly wage is 25. Overtime compensation is paid, what I said, with a 25% addition. So if for an employee work 47 works in 1 week, when the work, as I said, normally 45, they will have 2 hours of overtime. So overtime calculation, we will see here plus that means the hourly rate instead of 25 will be around 31 overtime paid, and then you can see the difference here. Rest days in Switzerland, normally you have to rest at least 11 hours a day. For adults, that can be reduced to 8 hours as long as the average rest time over 2 weeks is 11 hours. At the end of the week, worker must receive a rest time of 35 hours consecutively if you do work a lot, basically. Unless in urgent circumstances, it's illegal to work between 11 on Saturday and 11 on Sunday. It's rarely you see any shop except in the station that works basically at night in Switzerland. As I said, normally employers are not allowed. So it's forbidden to occupy work outside of regular day, yes, as we talked before. Night work for employees working at night, their hours should not go past 9 consecutive hours. So you're not allowed to do extra overtime, sorry, at night. And if you work temporarily at night, they should receive a salary bonus for at least 25%. Now, in industries like hotels, as I said, they have the special regulations, which normally they're not going to give you this. You're not entitled to any extra, basically, because that's the agreement when you work in the hotel, basically. So it's the condition of work is like that. We will see that, as I said, there is a couple of industries where they are regulated by Convention Collective de Travail, which is like a standard work conditions for everyone who works in the same industry. So that's why now they're striking to basically regulate this kind of things. Proof of working hours. Normally it should be with the employer, but sometimes you might work for an employer who doesn't have any system. So basically, it's better for you to register your working hours. Employers have a legal obligation normally to document the working hours. Of course, this is to protect your health and safety. But some of them, they do not have this kind of things, and it's your responsibility in case there is a conflict about payments of working hours, then you have to show that you have your schedule. And employer, if they don't have, then they lose. If they do have, basically, then the judge will check. We will have to come with more proofs if they do have their own schedule. So companies must be able to provide the daily and weekly working hours of their employees, including overtime and days off. Then nowadays there is a system once you log in and they will see everything basically. Employees benefiting from flexible work hours and salaries above 100,000, 120,000 can basically forget working hours. It's not obligatory. Now we're going to talk about the contracts. Is there any question about working hours? Okay. So work contracts in Switzerland, there is no form for the work contract. It can be verbal or written. The most important things is basically between two parties, and you need to at least know what they're doing and what is the salary. But there's no form or template or anything they should follow. If you have a verbal work contract, basically, the moment you start acting on this verbal work contract will be considered as you are working. Should pay you basically based on that. But of course, nowadays nobody will work on verbal consent. They need to be written to at least understand your rights and obligation. For the mostly essential information regarding the personal information, of course, and then the salary, holidays, workplace, work obligation, and length of employment for how long. This is the most important things in the work contract. So if your work contract missing one of this, then you have to ask for your employer to keep to add this basically. We have two kind of work contract, indefinite and temporary. Indefinite means there is no limitation. You are open-ended work contract. It gives you more rights, as we saw before. If you are from first year to the sixth year to the second year, of course, you are more rights as employee. Temporary work contract gives you less right because they can end at the end of the work contract, and basically the protection period we will see also it's different. But employers is try in general to have more and more temporary work contract, because as I said, it's less obligation for them and less protection for the employees. But if you have a work contract that is going from short for 1 year short term, and then the second year also short term, the third year cannot be considered as a short term. Even if they call it short term, you can basically challenge that in the court, and the court will give you rights, because employers cannot keep giving you short term if you're doing if it changed by its nature to long term, even if they call it short term. So the court will consider it as a long term, which offers you all the protections for a long term contract. That's what we call it, contrat à la chaîne. So they cannot keep going, giving you the same contract all the time and think that they are protected. Um, there's also different types of contract based on the sector you work in. Some industries are regulated by this is called collective labor agreement instead of work contracts. Basically, they have a contract template type that you as employer you cannot use different one. The holiday is fixed, the salary is fixed, the time working hours are fixed, everything is fixed. So you have to just sign this contract with your employee, and that's it. Basically, you cannot choose whatever you want. I think we talked about this fixed term work contract. So we got just, as I said, it's more protection for salaried worker from employers seek to evade work protection, which is we mentioned basically. This is all we mentioned. This is what we call standardized employment contract, the one with specific for industries. In some industries, not everywhere, of course, but in some of them, this individual are replaced with the standardized contracts. The clause, as I said, are non-negotiable. Basically, you cannot have more favorite clause to the employers. It should be in the favor of the employees. It's possible, but not the employers. This is the minimum here in this standardized contract. So if your industry has one of these, then you need to make sure first before you sign the contract if there is a standardized employment contract or not. If there is, you need to check if your employer offering you exactly the same things or not. If not, then basically you can attack them in justice and definitely will win. There's no. Um, so here we have example of industries: construction, beauty, call center, operation. And also that's different. There is a level from the federal level, which is the case now about this construction. This is now it's being negotiated. There's a federal one and there's a cantonal one as well. This is what we call collective labor agreements. Also applies for certain industries. Revenue and work conditions are determined by the collective labor agreement or Convention collective de travail. I don't know how to pronounce it in German. These are agreement between companies, group of companies, and union, multiple union representing employees in certain industry. Basically, this is where the patronat, or basically the employers and the employees and the syndicate will sit down and make sure that, okay, like for construction, for example, I believe the minimum salary is 6,000 in Switzerland. So that's what they need to get at least. Now the discussion that is ongoing is about including their traveling time between from work to from home to work, from home from work to home, including that in the working hours, which is the employers are rejecting at the moment. So some industries are regulated, heavily regulated. Employers are not allowed to get any outs this collective labor agreements. And as I said, they're discussed way in advance with all of these partners, that is the state, with the syndicate and everyone basically to agree on it. This is the minimum wages. I believe this is up to date and maybe not. If not, please double check if this is the case. It's not now. Also, couple of cantons they have the minimum wage. Not all the cantons in Switzerland. So you have in Geneva, Neuchâtel, in Jura, in Zurich, in Belleville, and in Tessa, basically. It's not a federal one, and the federal, we don't have any minimum wages. Only the canton, they are allowed to have minimum wages. But also, we don't know if this will stay in place because there is an initiative in the parliament, in the federal parliament, basically to bypass this minimum wages put by the canton, basically. We still don't know if that will happen or not. Cantons are not happy, especially the cantons who issued minimum wages. We will see how it goes. So minimum wages means that you cannot get less than this amount, brut, not net. And basically, whatever industry you are in, this is the minimum. Of course, not the industry that is regulated with the collective, because the minimum hours, minimum wages is more than that. But the other industries outside the one we saw, they have to give you this minimum. So that's the minimum wages. In Geneva, they introduced that in 2021. I believe in Neuchâtel, that was recently as well, or yeah. I think there's someone who would like, okay, just a second. Of course, then when this is also the discussion based on how what is the correct amount to live in Switzerland. Now, I believe in Geneva, there's also this initiative to stop the minimum wages for summer job for student. If it passed now, I believe they will have a referendum. So small jobs like summer jobs, they will not be subject to minimum wages. And internship, apprenticeship is not subject to minimum wages as well. Wage dumping, this is basically to protect employees in Switzerland from employers who wish to, that's the whole concept of this minimum wages, to not have wage dumping, like using a labor that is cheaper from different countries just to gain more. This is illegal, and this is normally always used with the employers based on the nationality of the employees and the legal status, basically in Switzerland. So they put the minimum wages to stop this basically this behavior, and they did this collective agreements to also stop the wage dumping. Bonus, we don't have in the Swiss Code of Obligation any definition or regulation regarding bonus. Normally, it's mentioned in the contract. Employees are not entitled to any bonus if that's not written, basically, in the contract. They normally are part of the salary. There's a gratuity, which is at the end of the employment. Bonus are also subject to tax. and Social Security. So basically, as I said, we're not entitled to receive any unless if it's written in the contract. If it's not written in the contract, we are not entitled, and must, as I said, must be outlined in the contract. So this is one things that you need to make sure that you have in the work contract if other employees have their bonus in their contract as well. Now, internship is doesn't constitute the definition of volunteering, and it's some of definition of the work contract basically. And normally, internship, I would say it's a kind of like a work, normal work. So it's not like apprenticeship we will see later. But internship is limited normally, and it's for the interest of the intern to learn, basically. So once you are at the university and your program will require you to do internship, then internship will be accepted, but you're not allowed to do internship in the industries, for example. If it's not part of your program or something, that will be different things, or it will be a work contract, normal work contract. Paid internship. Basically, unpaid internship are very rare here, unless if, as I said, if it was part of the university program. So it's you take credit basically once you complete the internship. It's like you're following a subject at the university or something. Mostly the United Nations, they don't offer any paid internship basically. They're always unpaid, but because they have their own specific rules in in the United Nations and all of these international organizations. So as I said again, it's the internship is basically considered as kind of studying. So basically, interns are not working, but getting information, getting experience, and that's why normally it's not paid and it's part of the university program. They still have to have protection like accident insurance because they are working in the organization, and contracts normally the university provide this kind of convention, what we call it, for the employees and the employers to sign. Apprenticeship, it's kind of different. Normally, it is similar to internship, but you undertake with the aim of developing specific professional skills, not overall skills, not overall knowledge, sorry, as a university, but here you're working as in a specific domain, and you're gaining professional skills to later on be able to work in these professional skills. Normally, they don't have to be paid, but often they are paid, and but they're not paid with the minimum wages we saw before. They paid less than the minimum wages because you also the employer also giving you a lot of time to teach you how, for example, to I don't know if you're a carpenter, if to build a I don't know some big wooden things. So they are offering you help to be able to continue later on by yourself, which is that's what you need if you're getting out of the school or something. Volunteering is basically unpaid. So still, some employers have a volunteering agreement in place. Some of them they don't. If you work, for example, in a race or something, or you help in a sport events or I don't know any culture events, they don't provide a work contract, anything. But they do have to provide you with the insurance in case you have any accident in the spot. For example, you have to be insured for accident insurance, but it's unpaid, and that is basically do not count as an internship or anything because you are helping, and it cannot be also helping forever. So it should be limited. It should be limited on time and on the duration. Here's some of the clauses. I don't know if you have any questions about the things I mentioned just before. Okay, no questions. Then I will move on to this
Yeah.
important clause. I chose clauses From work contract, basically the one you have to be careful when you sign a work contract, basically. And Switzerland, this non-compete clause are regulated by the Code of Obligation. Basically, it's to protect employers from potential damage that would result from an employee practicing activity that compete with their employers. So you need to make sure and make there is now it depends on the company, on the size of the company, and of course on your responsibility of the company. They might have this non-compete clause in the whole contract just for this one clause. So if you're this, you need to be careful because if you're working in IT, for example, and you find yourself like, okay, after the end of my employment, I'm not allowed to do a similar job for a certain amount of time in a specific geographical area, then it's okay to stop. But normally, what employers does is that they don't give you like they put 5 years, and you're not allowed to work in Europe at all. So this is not fair. The court, even if there is something like that in the work contract, the court will not accept it. Basically, you cannot stop someone from doing their job for this time and in every way. Also, the employers need to prove that there is damages from the activities you've done. So they need to be like what we call it link causal, which is like I as employer I lost this client because of this person. This needs to be proven that this person took this client with my with the non-compete clause, or with basically he's not allowed to do that, and I lost this amount of money because of this behavior. It's not easy to prove, to be honest, not easy at all. But this is a typical clause that you will find in mostly all the work contract here, and you have to be careful for it. So this is a point to negotiate in case you see, because sometimes also employer can put penalties, which is valid if it's not very huge penalties. For example, if you break this non-compete clause, you have to pay us, I don't know, 100,000 francs for violating this clause. You might see this in work contract. That doesn't mean that you will have to pay the 100,000, but at least employers put that to scare you. It depends on your work, it depends on your domain, it depends on your salary, it depends on many things. But of course, if you generate a lot of money, then you have to pay the 100,000. If not, then the judge will reduce it, but you still have to pay something, but it will be reduced. Discrimination in the workplace. This is the most difficult things to prove, honestly. So we have the law between to equality between men and women, but this is not only about equality between men and women. This is about equality for everything, non-discrimination, nationalities, colors, anything. And basically it's not easy to prove the discrimination. Normally in the cases now we still have, even we have this law for equality between men and women for almost 10 years now, even more, and we still see that men are receiving more salaries than women in the same activity. Now, how the authority will see that, basically once you submit the tax declaration, they will see if this person exactly doing the same job like this person and receiving better. Of course, you need to have the same qualification, you have to the same years of experience, you have to be exactly the same profile. And if they see that, then the employer will be fine, definitely. They will find the employer or they'll ask them to adjust the salary to be the same. So in case of interview or looking for a job and you see that you didn't get the job, and someone else in the same specific situation because they are Swiss or they're European or something like that, as I said, it's very difficult to prove, honestly, because employers, before they engaged with someone, they have million reason to say like, okay, we chose them not because of that, chose them because of their qualification, experience, their knowledge of this market, blah blah blah. So The only case I read, I didn't see, I read about discrimination was with against the state, basically. It's a woman that is attacked the state of Geneva, that the state of Geneva hired someone, a man, basically, because she believed in the interview, they asked her if she wants to get married or if she wants to get children, and then they basically decided to go with the man. She won the case because of this question that was asked in the interview, basically. Any questions regarding anything I said before? Okay, so now we're going to move to Social Security and taxes. Basically, everyone in Switzerland, resident domiciled in Switzerland, is subject to Social Security. First pillar, we have three pillars, we will see later. Social Security is pensions, pension funds, that is for you once you retire. And we have the first pillar that is AWS, the second pillar, what we call it LPP, PP, I guess, in German, sorry. And the third pillar is private one. So it's not mandatory. The first pillar, the AWS, AVH, AHV or AVH, is basically for everyone. If you work, if you don't work, except for student. If you work, if you don't work, you still have to pay the Social Security. It doesn't matter how much you earn. There is a limit, 2,500 per year, but you still can contribute even if your salary is less than 2,500 per year. It's mandatory for everyone. If you don't have any salary at all, then you will have either to pay the minimum or the authority will ask you to provide your wealth. They will base it on your wealth too. So if you're a wealthy person, then it will be might problematic if you don't work because they will calculate it based on your wealth. I don't know exactly the percentage, but there is a percentage that will based on your wealth. But there is a limit at the end how much they can take, basically. Just to give you an idea, even if you normally it start from the age of 18 to no for sorry from the age of 21, because we call it the échelle 44, which is mean the 44 years of contributing. Even if you contributed 44 years, that you will receive monthly around 2,500. This is if you contributed for the whole 44 years. Now the system, as they call it, Social Security, it's social. So basically, even if you earn millions, you will receive 2,500. If you earn 5,000, you will receive 2,500. Doesn't change anything. But the percentage, of course, they will take from the people who earn more. It's just to compensate in this social system. It's for old age, survival, and invalidity insurance that all included in the first pillar. Mhm. And it's also help for the in case of illness and accident, and if you have any handicap or something. Also included in this first pillar, the unemployment insurance. Basically, all of this we see now, it's mostly included in the first pillar, all of this. So the same percentage, it's around 5.4 for employees and 5.4 for the employers, plus the fees for the Social Security Authority. So basically, whatever your salary, as I said, they can take, even if your salary are 100 million, they will take, doesn't matter. You will see in your payment slip that all of this insurance are taken from here. Basically, that's what we see in the screen now. The first pillar, AHV, sorry, which is old age and survival insurance, and then we have disability insurance, and then there is the other insurance, which is like chômage and unemployment benefit and everything together in the first pillar, basically. So, as I said, you will see it employers has to pay this AVS. It's not optional. It's optional only if you have to leave the country to work for the same employer. Let's imagine if your employer send you to Germany, for example, to do a specific project to install a machine or something, you can still be able to contribute to Swiss Social Security to complete this 44 years. and not, but that's facultative. It's optional. It's not mandatory. The second pillar, also for only for employees, is not available for activity, freelancing activity. Just to go back, freelancers normally are also subject to first pillar. The percentage they pay around 8.7 or 9%. So they pay less social security than the employees, basically for the first pillar. And that's why we go back when I said that normally as a freelancer, you have to have three different clients because they suspect that the employers are pretending that you are a freelancer while you are hired by one employer and they don't want to pay your taxes correctly. So that's why the authority asks you to provide, to prove as a freelancer that you have three different clients. You have to show them that you basically invoice this different clients and that they paid you these different clients. And then they will, okay, they will believe that you're a freelancer. If you don't, there is two possibilities. Now, if you imagine yourself, you have a work contract for a company that is based in the United States, for example. This company is not subject to any social security because, as I said again, it's the obligation for the employer to pay social security. So they will deduct it from your salary and pay it. You don't have any relationship with the authority. Only your employer. Employer will deduct it from your salary and pay it. Now, if you have a work contract with the American company, this American company doesn't have any physical presence in Switzerland. So basically, the authority will come to you and say, look, you have to pay your share and the company's share from your salary because your employer is based outside Switzerland. Let's call it Anobag in the short term. We call it Anobag. That is employer outside Switzerland, basically. So most of the people after COVID, not most, a lot of people after COVID, sorry, they do have this work contract that is remotely, they work completely remotely. They have two solutions, either to register and they negotiate with their employer that's okay, listen, in Switzerland, we have to pay social security based on that I'm employed by you, but you are not here. So I will have to pay my half and your half at the same time. So please compensate me my half. Or you go to what we call it payroll companies. These payroll companies will hire you basically to work for them. They will be your employer of reference, we call it. They will have a contractual relationship with your employer in the US, and then they will just give you the task to work for this employer in the US, and they will be basically your employer in Switzerland. So that will give you more protection regarding vacations and all of that. And now that's it, a lot happening nowadays because of this work remotely everywhere in the world. Weirdly, so because we still have after COVID many question marks regarding this working remotely. Like for example, the second pillar, you are employee, that you are not subject for the second pillar, for example. Even you are working remotely, you're still employee. You have one employer and everything, but you are not subject to second pillar, for example, the LPP. Second pillar is to come because, as I said, first pillar will not be sufficient for you, even if you paid 44 years. It's not going to be enough for retirement in Switzerland. The maximum you will get 2,500, not enough to rent a place. So basically, you have to get at least second pillar as employee. It's not possible also for a freelance activity. Freelancers are maybe couple of legally you're not entitled, but if you wish, there is a couple of insurance company that will cover you, or you go to the third pillar, which is a better option now because second pillar also there is something good if you are you can buy back, for example, to increase your return at the end of retirement. There is a cap for that. You cannot buy back as much as you can. You can buy at least, I guess, 20% of your revenue or something. There was a new jurisprudence come just recently to protect basically the case, which is the companies from this because this what you buy back is basically tax deducted, so you don't pay taxes if you're, for example, I pay back I buy back, sorry, 50,000 francs worth of retirement, or I put 50,000 francs in this authority, then I don't pay basically, I don't pay on taxes on that. Third pillar is completely private, is up to you to decide. There's a flexible one, what we call it flexible pension 3B, and there's a tied pension 3A. Tied pension means you, if you take it out before the due date, then you lose money. The flexible pension is mostly offered by banks, and yeah, banks basically. It's also give you some advantages, tax advantages, both of them, 3B and 3A. Of course, for employees to be able for retirement, always for retirement in Switzerland, you have tax privilege, basically, if you wish to contribute for retirement. And now, last year, sorry, or 2 years ago, they allow you also to buy from your third pillar. So also you can buy, increase your shares in the third pillar to receive more in the future, and that will be tax deducted as well. But it's completely up to you. There is no even employers, they don't force you to have anything. The employers will have a better options for the second pillar. That's almost always the case. The companies offer them better protection for the for two insurance, basically, that second pillar and the one if you are sick and you cannot work, basically. So I believe we talked about all of it. Here, as I said, the contribution. Tac. Regarding the second pillar, sorry, if your salary, there is a cap. I think your, what we call it, salary, I don't exactly know the terms, but there is a cap between 2,500 is the entry level. So if your salary is less than 2,500 per month, you are not subject to LPP, the second pillar. You have to earn more than 2,500 per month to be included in the second pillar. I think the cap is that between 2,500 and 128,000 is the salary they calculate. Basically, that's the salary you pay LPP on. Even if you earn 500,000, you still have to pay on this amount. Unlike the first pillar, what we saw, if you earn millions, you still have to pay exactly the same things. So the system, the second pillar is different in this subject. And chômage, which is the unemployment basically included in the first pillar. You have to work for the last 2 years. So if you start working now, for example, and you look back 2 years, you have to be completing 365 days in the last 2 years. One employer, five employers, doesn't matter. You have to continue to contribute to the AVS for the last in the last 2 years for 365 days, and you will be able to get. If your salary is fluctuated in this way, then they will calculate your all salaries you received in this period, and they will see the average, and you will receive 70% if you're a single person with no children, and if you're married with children, and you might able to receive 80%. The moment you know that you will be ending your work, you have to go to the unemployment office and register. You don't wait until the last day of your work. You go immediately once you receive the termination letter and go register, basically, because the unemployment office might be able to help your employer to keep you at work. They might offer to pay half of your salary, for example. They might, if I don't know, if you have like a problem working standing, to offer the employers a possibility for you to work sitting or change, or they might give you some courses to be able to do another job. So inform them immediately. Don't wait to last minute, because they have a lot of offers to offer the employers to keep you at your job. But in any case, you need to remember that unemployment insurance is a step to prepare you for your next job. So it's not basically a holiday. You have to do a lot of research. You have to follow a lot of courses. So they will be almost working. You're almost working completely. They don't want you to feel like, okay, I'm unemployed, so I will be like able to travel to do this kind of things. No, you have to sit and you have to go every month to see your assistant, basically, and see if you're doing well. If you don't, then they will basically stop giving you, and per days they calculate it normally. And yes, they are harsh normally, to be honest with you. So you need to be careful. Going back to this, the unemployment with the permit. So if you are a EU citizen and you are unemployed, entitled to chômage, basically to unemployment, you are allowed to remain in the country to receive your unemployment completely. Now, it's not the case if you are not non-European, because chômage, as I said, is one step before your next employment. So if you are not able to work because you work, your B permit as a non-EU citizen is subject on is given because you're working. So the moment you lose your job, basically there is no reason for you to be in the country. As I said again, everyone needs to have a reason to be in the country. So if you're non-EU and you are terminated, basically the office will tell you, the unemployment office will tell you, go to the immigration, renew your permit, and come back to us. Now, if you go to the immigration and they see that you don't have any work, they will say, no, we were unable to proceed with your renewal. So everyone will throw the ball in the other person, in the other authority, and at the end, you won't be entitled to receive unemployment. Of course, if you have you renewed your permit in November and you terminate it in December, then you will be able to get it. As I said, it's a yearly one, so almost until the end. But if you're terminated in November and your permit is valid until December, then you're only entitled for 1 month, and even this 1 month, the unemployment office might make a problem for that also. So for European, again, they might receive this L permit. Is this is the case only to receive the unemployment, because by the free movement agreement they should be. Then there is no discrimination between a Swiss citizen and EU citizen. But this is very important to keep in mind, that when the moment you are terminated, go immediately to an unemployment office. I think we talked a little bit about this. This is the salary must earn at least to 22,000. So I believe that will makes it around no 1,800, something like that. If you have a multiple employers, they need to income their total income to be basically reach this yearly amount. Again, it depends on your age for the LPP. Basically, it's not fixed like the first pillar. It depends on your age, but I believe it's around 6% or 5%, something like that. So your employer will mirror 3% and you pay 3% on this one. Um, I think we talked about all of that. So this is also we talked about Swiss toast. Yeah. Okay. Okay. I believe we covered all of that things. Social Security contribution also we did. Yes.
Is there a concept of like 13th salary, or the salary is defined by the employer in the contract? How does it work?
They don't have obligation to offer 13 salary at all, unless, as I said, if there is a collective labor agreement and they provide 13 salary, then they cannot do less than that. But there is no obligation for the employer to offer 13 salary. They might offer 12 salary. It's completely fine. No problem. If they do offer 13 salary and you stop working in the middle of the year, they need to calculate this 13 salary, including in your salary. If you're working for I don't know, pro rata we call it. So they need to include it also on your vacation. They need to include it in everything. If they do offer it, they need to include it in your hourly salary and everything. Basically, it should be compensated with the
In terms
vacation.
of Okay, and in terms of number of vacations, what law is saying? How many?
It's 3 weeks minimum. If you're
Mhm,
per year, it depends also in the how many years you are in the company. But
mhm.
3 minimum, maximum, there is no maximum, but just 3 weeks minimum per year. If you
Okay.
work for almost more than 10 years, I believe then it should be 4 weeks.
Okay. Thank you.
You're welcome. Also, this one, if there is a standardized work agreement, then there might be more, but that's the minimum. When we say minimum by law, it means that the employer cannot give you less, but they can give you more as much as they want. But they cannot derogate and give you like, okay, we'd like to give you 1 month. And they are not allowed also to compensate you money instead of vacation. So if you're entitled to vacation, you need to receive it vacation, unless if they terminate your contract and they give it to you as a money at the end. But this is not allowed as well. But what
In terms of
employers
the
do
carrying out,
normally, sorry?
in terms of the carrying out vacations. So, for example, I did not utilize all my vacations in the current year.
Mm.
Am I entitled to carry forward for the next year? And if there is a limit for that?
That's a limit put by employers normally, but you should be able to
Not
take
by
your
law, not by
not
law,
by
by
law,
employers.
by
So meaning
employer.
that if employer does not put any limit, I can carry forward
Yes,
for
but
as much as
normally,
I want.
normally, normally you should take your vacation in the year. By law, it's not an obligation, of course, but you should be able to take your vacation in the year you're working. You need to rest,
Mhm.
basically. So that's what the law provide. But there is, if you don't rest for, you still have 1 week. Normally, most of the employer ask you to take it by February. So
Mhm.
not to continue having a lot of vacation afterwards. And as I said, because they cannot compensate the vacation, normally they
Mhm.
have to give it to you as a vacation. And they have to give you the vacation. They cannot pick the days. Some companies do, for example, schools, they tell you to take your vacation in the school holiday. But it depends on the activity, it depends on many things. So normally employers are not shouldn't tell you exactly when to take your vacation.
Thank you.
You're welcome. Okay, so this is withholding tax that is also important to mention. All B permit holder in Switzerland are subject also um, all permit holders except C permit or someone married to C permit holder or a Swiss citizen are subject to withholding tax. That means that your income tax will be paid at the source. So unless if your salary is up to 184,000, then you have to do a tax declaration. No, sorry, if your salary is more than that, I believe. No, that's for different things. Anyway, most of the employer must take from your salary the withholding tax and show you in your payment slip. Of course, that depends on your situation. If you're married, if you have children, then you will pay less. If you're single, then that will be A0 one, and depends on your salary. It's progressive, so the more you earn, the more you pay, basically. But I believe the minimum you need different from canton to another. I believe in Geneva, if you earn less than 2,000, something like that, you don't pay a withholding tax. But I need to double check. Of course, if you're married and if you're not married, then you don't pay until you earn more, basically. This is in case you wish to get to withdraw your social security benefit, like the first pillar or the second pillar. Just to tell you, for the second pillar, it's easy. Not for European. European are not allowed basically to receive to withhold their social security, but for rest of the world, basically, it's possible. And LPP normally is the one that you get more because it's more. And Social Security, as I said, you will be able to receive it if there is no agreement, Social Security agreement between your country and Switzerland. And Switzerland basically signed a lot of Social Security agreement with a lot of countries around the world. So that what they will do is to transfer it once you leave to another country, to transfer it to this the authority, the pension authority in the country you moved to. So I put here example for Ukrainian national are entitled to refund of their RDS contribution upon permanent departure. So you have to declare your departure from Switzerland, and provided they're not entitled to a Swiss pension. Procedure, you have to submit an application. Of course, it will take some time and they will deduct many administrative fees, to be honest with you. And the amount is not going to be, unless, of course, if you work for a long time. LPP, upon permanent departure to non-EU EFTA country, like Ukraine, individuals can withdraw both the mandatory and supplementary because this is the employer, as I said, they might give you even more protection, more benefits, sorry, for the LPP, which we call it the mandatory and supplementary portion of their occupational pension. Easy, honestly, not difficult at all. To go through your LPP is fast because the companies normally are normal insurance company, not like state pension fund. But of course, you have to pay taxes on everything withdraw. Sorry, so they will be subject to withholding tax even if you wish to take them. You can take the LPP in one lump sum and leave basically. You can take your LPP also. That's important. You can take your LPP if you wish to start your own freelancing activity. So basically, if you were employed for 10 years and you accumulate a good sum of pension in the Social Security and the LPP, you can use that either to buy a place, for example, or to start a freelancing activity, which is also beneficial for you to have the capital to start, basically. So you need to submit business plan and you need to explain that you're a freelancer and you explain like your client's base, of course, with the business plan and everything. Condition to withdraw Social Security. That is what I said. Now you have to be careful because they will be subject to withholding tax and the timing. You have to leave you have to have the declaration that you left the country basically. And basically that's the documents you have to, as again, LPP is subject to whatever the company decide. Now, this is any questions about the Social Security system and all of these taxes? Okay. This is possibility for not everyone, of course, but financial assistance for employers given offered by the canton, basically. Certain cantons offer financial assistance for employer hiring immigrants, notably resident under the F or S permit. In Geneva, the Hospice General can offer up to 40% of the employee's salary for up to 6 months. So they will, because normally employers are hesitant to hire someone with the unstable income and new to the country, basically. So for this 6 months, of course, it depends on the size of the company. Of course, not all companies can, if your company only one, two people inside, it's not possible to be able to get this 40%. So the size of the company very important. There is a conditions about the company what you can get if this will at least get some experience, know-how, this kind of things. Then they will do offer the 40% for the up to 6 months basically. They can also financially support further training if needed. So you can basically, now I was in a meeting yesterday or 2 days ago. If you work in a temporary job, they created a foundation for this temporary job employees to be able to follow a courses, specific courses, to be able to later on be hired permanently. So there's a lot of benefit for people who are basically either in this situation of F or S permit or working temporary, basically. Finally, they also offer professional coaching, administrative, of course. And here I put EVAM that they do have exactly similar, it's almost the same actually. In Geneva, this is the condition people with provisional protection or status as financially assisted by hospice. Be familiar with the job market, motivated to work in Switzerland. All of that things, of course, you need to have. And if you wish to start as a freelancer, normally before, as I said, you needed to have authorization. It's not the case now, but you still have to submit a business plan as a F permit or S permit holder. One of the things they ask if you're familiar with the market and you are basically know Swiss market, the sector you're working in. So basically, what you're doing now in Babylon is something that will makes you qualified to understand the Swiss job market, basically, for the immigration or for the authority. This is the conditions for the EVAM, then stable employment, permanent. Yeah. This is here, it's important for you to understand the termination, contract termination. There are many provisions in Swiss law that protect employees when facing termination. The first few months of work are often a trial period, 3 months basically. And during this time, an employee can be terminated with a notice of 7 days at any point in the trial period. So the first 3 months, the termination is 7 days in advance. They need to tell you, the employer needs to tell you that the contract is finished. Once you pass this 3 months, now we get in the first year of employment. Once during the first year, you're entitled to 1 month's notice. So the employer and this 1 month start from the end of the months. So for example, now we are on the 6th of November. If I receive the termination today, it's gonna be not 6th of December, it's gonna be end of December because the end of this month, a month. So that makes it end of December, I will be officially terminated and I don't have any rights in the company. Between the second and the ninth year of work, you're entitled to 2 months. So once you enter the second year, there will be 2 months notice period. From the 10th year of work, you're entitled to 3 months, always at the end of the months, always. So if you're terminated in the second, then you have to wait until the end of the month and then calculate 2 or 3 or 1 month. Protection period. In case of illness, accident, or pregnancy, employees are protected against contract termination for a limited time. This also depends, we will see example later. This also depends on the amount of time you have spent at a specific job and doesn't apply during the trial period. You don't have any protection during the trial period, basically. For the first year of service, the employee is protected for 30 days, as we said. If the employee can no longer work after being notified of the termination of their contract, the notice period stop. So if you, let's imagine that you will receive your termination today and you are sick tomorrow, okay? And you have a work report, a medical report that you're sick for 20 days. This period, the 30 days or the 90 days will stop. Will stop calculating until you come back to work and then resume. It's not going to start from zero. It will going to resume until you are basically the end of your protection period. So that's often the case. Most of the employees do that, is to prolong basically more the salary they will receive. But you need to remember that before we saw that you're entitled for this sick leave for up to 30 days in the first couple of years. And then, so if you use this 30 days, basically, there is no more payments for you. So if you're outside, then you are no longer, unless of course if you have an accident or something like that, then you have to go to a different authority and ask for their help, basically. But that's when if you have a sickness in the middle of your protection period, because protection period, what is it exactly? It's basically for you to be able to look for a job. That's what it is, basically. So here's the example. An employee with 6 months of service become ill for 10 days. Notice given during illness. The employer issued termination notice on the second day of the employee's illness. Protected period. In the first year of service, the employee is protected for 30 days from termination due to illness. So here the outcome is suspicion of notice period. Since the employee fall ill within the 30 days protection period, the notice period is paused during the 10 days of illness. Resumption of notice period. Once the employees recover and return to work after the 10 days, the notice period resume from where it left off. As I said, it doesn't start again, it's just resume. So extension of employment. If the original notice period was 1 month, it now extend by an additional 10 days to account for the sick period, effectively pushing the termination days 10 days, not the end of the month, so just pushing 10 days more. Here's another example. Anyway, as I said, I will send you all of these examples, so don't worry. Exactly same scenario, but the person here is for 3 years, become ill for 15 days. The employer issue termination notice for of the 5th days of the employee's illness. For a protected period, as we said, for the 2nd to 5th year, the protection period is 90 days for illness. So suspicion of notice period is suspended during the 15 days of illness since it falls within the 90 days protection period. Resumption of notice period after the 15 days, etc., etc. And another one after 7 years. So here you have everything. There is here I believe we're reaching the end. Jurisdiction and procedure for workplace complaint. Normally, what we call it in Geneva and Vaud, it's a prud'homme, the tribunal. It's free of charge, basically, and the procedure is it's a judge with someone from the syndicate and someone from the employer who will deal with the litigation, basically. As I said, it's a jury from various profession. Normally, you have to make sure that if you are terminated, you have 30 days to ask the employers to give you the reason for termination to see if it's justified and unjustified. You have a delay, I believe, also 3 months to attack if you feel that you are unjustified terminated. So basically, you have a delay. You cannot wait until I don't know, after 5 years you decide to attack your employer. It's not possible. So you have to act in the delay because otherwise you cannot reopen the litigation. So what I recommend, if you received your termination, immediately ask for one thing, the reason first of all, to have something written. Normally, all notification about termination needs to be come to you in a registered mail to be correctly notified. And once you are correctly notified, you have 1 month to ask for the reason of termination. The employers has to give you the reason in written. So this written reason where you can attack, for example, if they say that we're restructuring and they're not restructuring, they just like this is unjustified. Of course, it's still difficult because the employers can invent many reasons to fire someone. Basically, we have a termination with the immediate effect if you cause harm to your employer. For example, if you violate any of your contract rules, non-compete, confidentiality, this kind of things, the employer can terminate you immediately. If not, then they have to respect the protection period we mentioned, that they have to pay you your salary up to this 2 months or 3 months based on your years you spent in the company. So again, just the moment you receive any termination, act immediately. Don't wait and don't sleep on it because otherwise the court will reject the application immediately. I believe we arrived to the end. Any questions? If there's no questions, I believe I was super clear. Anyway, if you have any questions, feel free to contact me. This is my email. That's our phone number. And again, we will share this slides with you so you have it and you will have my email and our phone number. So please, if you do have any questions, ask now, even whatever you think. If it's a private questions, please contact me on the email or by telephone as you wish.
I would like just to thank you for a very detailed session. I think gave us all the information we need and even more. So thank you very much.
Thank you. My pleasure. Thank you. Thank you. So no questions. I will end this session. I wish you all the best. Here, I wish you all the best as well. So as I said again, if you have any questions or any... Yes. Hello. As I said, if you have any question, please don't hesitate to ask me. I will be happy to answer all your questions. So
Thank you very much.
Thank you.
you're welcome. Enjoy your day.
Good afternoon. Bye.
Have a nice
Bye-bye.
Bye.
Bye-bye.